Hello, everyone, and thank you for joining us today. I am Harry Atlas, a partner in Venables Employee Benefits and Executive Compensation Practice Group. I'm joined today by my partners in our practice group, Lisa Tavares and John Wilhelm. While we have all been focused this year on the impact of COVID on our employee benefit plans, the government, and in particular the Department of Labor, has been busy recently issuing guidance on other topics, including regulations, some final and others proposed, on topics that have a great impact on retirement plan sponsors and the retirement provider community. Some of the guidance relates to the Secure Act, enacted late last year, and other parts of the guidance addresses other issues. If you have any questions as we proceed with our presentation, please enter them into our webinar interface. We have a packed agenda today, but we'll try to answer as many questions as possible. So with that, let's begin. The first topic that we're going to talk about today is the Fiduciary Regulation Proposal from the Labor Department. By way of background, ERISA imposes fiduciary obligations on investment advisors, the plans, and there's been a push by the DOL over the past decade to expand the scope of who is considered a fiduciary investment advisor. And most recently, a major regulatory package was finalized in 2016 but was invalidated by a federal court in 2018. This summer, the DOL issued another regulatory package addressing the issue. Currently, most of the package is in proposed form. Many comment letters were submitted and the hearing was held in early September 2020. At this point, we are expecting the DOL to potentially finalize the regulation package at any time. So what is the proposal in the package about? So we start with the definition in ERISA. ERISA defines the regulations that were issued shortly after ERISA was enacted define who is an investment advice fiduciary using a so-called five-part test. This test, which we'll go through at a high level, was changed pretty substantially in 2016 in the final regulations that were now vacated and has been restored by the Labor Department in its current action. The five parts of the test are as follows. To evaluate whether somebody is an investment advisor, a fiduciary investment advisor, you look at whether they're rendering advice to the plan with respect to investments, the value of investments, advisability of investing, purchasing, selling securities, kind of what you would think of as an investment advisor. But then there's some additional parts to the test, and this is where some of the issues arise. The regulation says that they have to do so on a regular basis, pursuant to mutual agreement, arrangement, understanding with the plan, that the advice will serve as a primary basis for investment decisions with respect to the plan, and that the advice will be individualized based on the particular needs of the plan. While the DOL in its 2020 proposal has restored the original language, the original text of the five-part test, the preamble to the regulation has pretty significantly diminished some of the additional prongs of the test that had previously served to limit who can be a fiduciary. And stated differently, they've potentially expanded who can be a fiduciary investment advisor. For example, the first prong on the regular basis, that the advice had to be provided on a regular basis, had previously been understood to require an ongoing advisory relationship for advice to be considered fiduciary, and now the DOL has said that the first advice interaction with an advisor can be fiduciary in nature if a relationship later develops. Another example, one of the prongs is that the advice has to be given pursuant to a mutual agreement, arrangement, or understanding, which previously had been understood as a fairly objective criteria that there actually had to have been an agreement in place. And now the DOL has said that this can be satisfied based on the reasonable understanding of the parties. So step one is that the DOL has expanded what type of advice relationships can be fiduciary in nature. Another important piece of the puzzle is there's been an advisory opinion out there that's been out there for 15 years that has stood for the proposition that if a retirement plan participant in an employer-sponsored plan gets advice from an advisor that is not a plan fiduciary and is not promoted or selected by the plan sponsor, and that advice is to roll the participant's money out of the plan into an IRA in order to access additional investments. For the past 15 years, the Department of Labor has said that that is not considered fiduciary in nature, a so-called Deseret opinion. As part of this regulatory proposal, the Labor Department has withdrawn the Deseret opinion, and as a result, an advisor to a participant advising a rollover out of a plan potentially could be fiduciary in nature. So we have the DOL expanding the scope of who could be a fiduciary investment advisor with all the attendant requirements and prohibitions under ERISA, and we have the withdrawal of the Deseret opinion, allowing rollovers potentially to be fiduciary. So what's the remedy? And the issue specifically is that if a fiduciary investment advisor gives advice to a participant that causes the fiduciary investment advisor to receive an additional fee based on the advice, that's a prohibited transaction. So the Labor Department has a prohibited transaction exemption that allows that advice to be given if numerous conditions are met. And this covers all sorts of regulated advisors, RIAs, broker-dealers, insurance companies, and banks. And it imposes some impartial conduct standards. So in order to allow the advice to be given and the fee to be paid, the advice has to be given in the best interest of the participant, which means that it has to be prudent and loyal, which are ERISA concepts. There has to be no more than reasonable compensation paid and no materially misleading statements. There also has to be disclosure of the fiduciary status of the advisor, the description of the services that will be provided, and disclosure of material conflicts of interest. And in addition, the financial institution, whether it's an RIA or an insurance company or a broker-dealer, has to have policies and procedures in place and has to have a review process at least annually to ensure that these safeguards are being met. So there's a lot of technicality here, and it's in the regulated community. This is a really big deal. From the plan sponsor's perspective, wanted to try to boil it down to a few points that I think would be most relevant from the plan sponsor's perspective. For plans that have a classic co-fiduciary advisor relationship in place, usually under so-called 321, which is a co-fiduciary, or certainly if you're a 338, which is a discretionary investment advisor, that status has always been fiduciary and is not really affected here. But there may be more of an effect from smaller plans that might have a broker or a consultant involved who's paid based on commissions or revenue sharing. That sort of relationship is likely to become fiduciary, and the broker or consultant will likely need to rely on the class exemption that we discussed. And for plans of all sizes, one particular area where this hits home is rollovers and participants who are eligible for a distribution. It's common for a record keeper call center to take calls from participants who are leaving the plan and to ask about, what are my options? And under this guidance, it's very possible that the call center could be considered a fiduciary, particularly if it's advising the plan sponsor to roll the money back to an IRA that the record keeper maintains. So that's something that plan sponsors will want to keep an eye on as well. And with that, I'm going to turn it over to Lisa to talk about our next topic.
Thank you, Harry. I'm going to talk about the final electronic disclosure regulations that were recently issued by the Department of Labor. There are 2 new voluntary safe harbors for retirement plans. This does not apply to health and welfare plans. In terms of supplying information for retirement plans, all the required disclosures, there's the option to use website posting. That would be a plan administrator that would provide a website, and certain notices, which we'll talk about more, will need to be provided in order for that safe harbor to be complied with. The safe harbor applies to covered individuals, which would include a participant, could include a beneficiary or some other individual who is entitled to receive a document under one of the ERISA requirements. The key to this electronic disclosure and much of what the regulation about is the validity of email addresses, either an email address or a smartphone number. And we'll talk more about the email address, but there are pages and pages of the regulation that go through and talk about the plan administrator's responsibility to provide a valid email address and to basically ensure that that is maintained through whatever period in which you're providing disclosures to a participant who's still your employee. The second safe harbor is the email delivery, actually direct email delivery, in which the plan administrator would send documents, notices, disclosures that are required under ERISA, again, to a valid email address of a covered individual. We'll talk more about that also. I would keep in mind here that while there are these new safe harbors, the 2002 DOL safe harbor option is still available, and that option applied to employees with computer access who were participants in the plan. They could actually get a notice reliably at their computer. So that depends upon the demographics of the employer, whether you have people that actually all have computers and are sitting at desk. And also the other category of people under that existing safe harbor were people that affirmatively consented to receive those notices electronically. The safe harbor requirement, as I noted, has a couple of different notice requirements. The first is initial notification. There's a one-time notice that has to be provided to basically inform covered individuals that they are going to be furnished with all their required disclosures through electronic delivery going forward. So this is a default rule. If you follow the requirements of the regulation, you're defaulting people to this electronic delivery, but they have to receive this one-time initial paper notification. They also need to receive a notice of internet availability when one of the required disclosures is actually posted on the website. So the notice of internet availability must be provided to valid email addresses that are provided by the employer, rather the participant, or at an employer-provided email address, which presumably works because of your active employee. This is more complicated with respect to terminated employees who may not have an email address for. The notice of internet availability would need to be sent each time a covered document is posted. There is a way to send an annual notice, but it'll need to be coordinated and you'll need to align with the various ERISA deadlines in order to make that work. The notice must sufficiently describe that a document is posted, the email address or a hyperlink to that specific document that's posted on the website must be included in the notice of internet availability. And that disclosure must be posted for at least a year. or until it's superseded by a new version. So it could need to be posted for a longer period. So I'll give you an example. You could have a summary plan description that you post in, we'll just say 2020, and that notice, you could have an amendment after you've provided the various notices. You could have an amendment to the plan that would require that summary material modification now to have a notice of internet availability. You would still have your SPD, you would have your SMM, but we know if an SMM is issued that you need a new SPD within 5 years. So in 2025, the new SPD would supersede the old SPD if you hadn't posted it. That's well after a year, obviously. Another example would be a blackout notice, which is one of the required or notices that are subject to these rules. And a blackout notice, if you were making some change in the plan, for example, we'd say a blackout notice is required in January 2021. In that case, even though the blackout notice has a short time of actual applicability, it's going to be 30 days in advance of whatever event. It's going to explain the period of time in which trading or other capability is not available in the plan. That might be a total 45-day period, but that notice still needs to be posted for a year, so it would have to stay up into January 2022. That's just the way the rules work. The safe harbor requirements also require that the participants have a right to request a paper notice or disclosure. They get one free copy of the paper. All individuals must have the ability to opt out of electronic delivery entirely. So there must be instructions in the disclosure, or rather the notice of the notices that are sent on how to opt out when you're first notifying participants of the electronic delivery option. I already referred to the email addresses. The plan administrator is required to maintain continuing accurate email addresses for employees, and then after employee termination, then the plan administrator would have to figure out a way to continue to receive those addresses. If the plan administrator gets a bounce back, an indication of an invalid email address, then the participant should be treated as opting out and they should receive paper delivery. The plan administrator is required to take reasonable steps to protect the security and privacy of a participant's personal information, even though you're now sending it out in these electronic formats that the participant has not opted out to, presumably if they're continuing to get it. And then with respect to the terminated participants, again, there must be reasonable steps to obtain an email address. So likely the easiest thing to do, or at least the minimum requirement, would be to obtain a personal email address as part of the offboarding process. There's an alternative safe harbor in these new regulations called the direct email delivery, which I referenced. And for the email delivery, some of the same rules apply. The notices still have to be readable. One of the requirements that applies to both the website and email delivery is that there needs to be a printable option of the disclosures that are being provided. So either your email would need to be able to be printed or the attachment to it would need to be printed. And similarly, if a website is used, there needs to be a printable option so people can obtain that information. Or, of course, as I noted, they can request it in paper. The same requirement for confidentiality applies, etc. And no website is required, but certainly a website where documents could be listed is not prohibited under these rules. lastly, I would just note that there's a reasonable transition period for plan administrators. And these rules, presumably in the 401k, 457B, and 403B environment, are going to be handled by the third-party administrators primarily. Plan sponsors are relying upon those administrators to help them to get documents and disclosures that are required under ERISA out to participants. That has pros and cons. I suspect that there will be less ability to make changes to documents with all of these electronic requirements now under the current rules. But there is a non-enforcement policy through this 18-month period, and that's really focused on the participant email address issue. There were a significant amount of comments with respect to the ability and inability to obtain and reasonably collect email addresses from people. And this guidance is from the Department of Labor. There's separate guidance that is expected potentially from the IRS and Treasury with respect to electronic disclosure for notices that are under their jurisdiction. So this is related to Title I notices. So I think now I'm turning it over to John.
Hello. I'm going to talk to you briefly about a new requirement for benefit statements that they include periodically lifetime income illustrations. Congress and the administration were concerned, and have been for some time, that folks are simply not saving enough for their retirement. And one of the ways that it was decided to address this was by requiring in the Secure Act that the Labor Department come up with rules under which benefit account balances could be converted in benefit statements to reveal what a monthly annuity could be purchased by that account balance. So the rule that will take effect 1 year after it's published in the Federal Register, which should be soon, the publication, since the Labor Department has actually already issued an interim final rule, which for those that want to read it is under Labor Regulations 2520.105-3. This rule applies to defined contribution plans, such as a 401k plan, that would also include for example, a 403B plan that's subject to ERISA for those nonprofit organizations that sponsor those. The rule will require that once a year, a benefit statement for the defined contribution plan will have to show the single life annuity into which that account balance could be converted, and also the qualified joint and survivor annuity that could be provided by that account balance. Now, importantly, plans do not actually have to offer those type distributions. They simply have to show once a year in their benefit statements what type of annuity could be purchased. Now, in order to convert to a monthly income stream, assumptions have to be made. And that's where, the devil is in the details. And I think this is perhaps the most important part of this for those who may have to explain those benefit statements to participants need to understand. Because without knowing what the assumptions are, these illustrations could be very confusing. So the assumptions are, first, the assumed starting date for the monthly payments would be the last day of the respective benefit period for which the statement was issued. It's assumed that the participant will be age 67 at that time, or if the participant's older than 67, that the actual age will be used in the illustration. the life annuity will be a life annuity without a survivor benefit. So what that means is the monthly benefit that would end when the participant dies without any further payment to anyone. The described qualified joint survivor annuity would be an annuity for the participant's life, an annuity at 100% of that amount for the remaining lifetime of a spouse of an equal age. So what that means is that when the participant dies, if a spouse survives, that same amount would continue to be paid for the lifetime of the spouse. Now, this qualified joint survivor annuity illustration will be shown even if the participant is not married. There has to be an interest rate assumed as to what amount the balance will earn while the annuity is being paid out, and for that purpose, a 10-year constant maturity treasury rate will be used. And finally, gender-neutral mortality tables will be used, that are currently used for rules that apply when qualified joint and survivor annuities are provided by a plan, so that the illustrations will be the same regardless of whether you're male or female. As I say, I think it's very important for those of you that will have to answer questions to understand these assumptions, because otherwise I think these statements could be confusing, and I think there's actually some concern out there that they may end up being confusing, unless folks really understand the assumptions. One important item I will point out that this does not include: there is no assumption being made as to future earnings on that account balance before the annuity actually begins later in the person's career. Further, there's no assumption being made as to future contributions that might be made to the account. So, particularly for new employees, this monthly annuity is likely to seem to be quite a low amount that would be paid by the plan, and hopefully that will encourage, I suppose, those younger folks to continue to contribute and perhaps to contribute even higher amounts throughout their career, so they can watch as they get future annual illustrations that those would grow. Now, there's an alternative to the assumptions that I just stated for plans which actually do offer distributions in the form of these type of annuity contracts that are purchased from insurance companies. So for those, the illustrations would actually use the assumptions made by the insurance company, except for a few items. That is, that the benefits would still commence on the last day of the benefit period, that the participant is 67 or, if older, the actual age, and that the participant has a spouse of an equal age and for the qualified joint and survivor annuity, again, regardless of whether the participant is married. Now, there is going to be model language, and there is in the interim final rule, that can be used to explain the lifetime income options. And the employers that use the assumptions provided in the rule and the model language for these illustrations, will not be held liable if participants cannot actually purchase an annuity that provides those projected benefits at that time. So using the model language, explaining the assumptions is very important, and the model language is probably something that you're going to want to keep at hand to be able to point out the assumptions being made to folks that have questions, about their lifetime income illustrations. So with that being concluded, I'll turn it back over to Harry Atlas.
Thank you, John. The next part of our program is going to focus on two DOL proposed regulations. These are both in proposed form. One of them is the so-called ESG proposal, and ESG refers to environmental, social, and governance, which refers to an investment style that seeks societal benefits above and beyond just the pure financial return of an investment. And the other proposal, which was issued a little bit after the ESG proposal, but really is similar in spirit, is the proxy voting proposal, and that relates to the fiduciary obligation to vote proxies that are available for securities held by a retirement plan or an ERISA plan. And to start out, by way of background, as we know, ERISA requires plan investment fiduciaries to act prudently with respect to selecting plan investments, which has always meant following standard investment protocols with respect to portfolio construction, risk-reward analysis, and so on and so forth. The DOL and courts have always held that the fiduciaries of a plan have to focus on financial benefits to participants. And the exclusive purpose of the plan is to provide benefits to participants, and that has to be the focus of the fiduciaries when they're investing plan assets. However, this becomes nuanced when we talk about ESG investing. And just as a matter of terminology, at different times, the Labor Department has used the term economically targeted investments, ETI, which oftentimes they think of job creation, helping a specific geographic area, perhaps, and ESG, environmental social governance, which is more thematic and can potentially result in the exclusion of specific industries. So, as a matter of terminology, I'm not going to go through all this in detail, but suffice it to say that there's been a long background here. The DOL started out with the notion that, as I said, that it is a fiduciary obligation to attend to plan assets, proxies. That ESG investing is not inherently bad, but it has to be at least as good as something else. So that in 1994 we came out with what was referred to as the all things being equal test, and the DOL has kind of vacillated around that, with saying, you know, you can take into account ETI factors if all things are equal, and then emphasizing that, and then de-emphasizing that, and saying that, well, you know, ESG factors can be among the things that you take into account in evaluating it. And now at this point, as we move into 2020, the DOL is coming out pretty firmly and saying that we really want to, in a sense, discourage ESG investing unless you really have shown that it truly is there truly is an equal an equation among the different types of investments. And the terminology here is difficult. First of all, DOL recognizes there's no specific definition of an ESG investment. For defined contribution plans that use investment funds, and for DB plans as well, an ESG fund either has ESG in the name or in the mandate. And the DOL also recognizes that there's a different calculus for defined benefit plans and participant-directed defined contribution plans versus plans where there's a fund menu. For employer-directed plans, if the employer chooses an ESG investment, that means the plan assets are going to be invested in that and not in an alternative investment. So the choice by the employer to use an ESG investment displaces other investments. Whereas for participant-directed plans, adding an ESG fund to the menu simply makes it available, but doesn't necessarily mean that it will displace other assets. As I said, the current proposal reflects the DOL's belief that it is actually unlikely that quote, all things will be equal between the ESG investments and not. And the DOL is emphasizing to fiduciaries that they have to make their decision based on pecuniary factors as opposed to societal benefits. The bottom line is, can a plan do ESG investing? The answer is yes. However, for a fiduciary of a DB plan or an employer-directed DC plan needs to conclude that the ESG alternative is economically indistinguishable from a non-ESG alternative, and needs to have a written analysis supporting that. So that's a pretty steep bar for an employer to take ERISA plan assets and invest them with societal goals of the ESG type. For participant-directed account plans, the standard is a little bit different. The DOL wants to see that fiduciaries are using only objective risk and return criteria in selecting and monitoring the fund, and they don't want to see an ESG fund added as part of a qualified default investment fund. With respect to the proxy voting, which is really the corollary to this, we also have a long and varied background from the DOL. DOL started in 1988, recognizing that voting rights of securities held by a plan are an effective plan asset and have to be managed as such. And over time, the DOL's position has evolved with respect to the plan fiduciary's obligations to exercise voting rights or to engage in shareholder activism. And in 2008, the DOL came out with guidance that tried to make it clear to participants that they didn't to plan fiduciaries that they didn't necessarily have to vote proxies. And in 2016, the DOL kind of moved away from that and made it seem perhaps more obligatory for fiduciaries to vote proxies. So where does that leave us? There's kind of been a lot of vacillating here, just like with the ESG proposal. The current proposal is also is evidencing the DOL's current position that plan sponsors should not be engaging in shareholder activism or even in voting as proxies unless they believe that the financial benefit to the plan of doing so will exceed the cost of the research and the time that it takes them to properly vote. So, and the DOL is being clear that there's no obligation to vote. Rather, it's kind of putting the thumb on the scale in favor of you really shouldn't be voting unless you've determined that the financial benefit to the plan of doing so is going to be worthwhile, taking into account the cost. What does this mean from a plan sponsor perspective? If you're a participant-directed defined contribution plan, probably like many of our members of our audience, the proposal will really have limited impact because these plans typically don't have individual securities. They typically have mutual funds, which there's really not, the fund manager votes proxies of the underlying securities. It's not really a plan level issue. One area where this will impact for the typical 401k, 403b plan, or 401k plan, if the plan uses the collective investment fund, the proposal says that the collective investment fund manager has to have a policy for proxy voting. And the collective investment fund manager is likely to require the plan sponsor to adopt the collective fund manager's proposed policy with regard to proxy voting. This will certainly have a bigger impact for defined benefit plans, and to the extent there's any defined contribution plans that are employer-directed, particularly those that invest in construction, real estate, infrastructure, things that actually do have a significant impact on society. Those sort of investments would come within the ambit of this and would certainly be affected. And with that, I'm going to turn it back to John.
So I'm going to talk to you a little bit about pooled employer plans. There was a concern, and is a concern, among the administration and Congress that many small employers do not have retirement plans for their employees. And it's thought that part of the reason is simply that the thought that the administration of those plans would simply be too difficult for many small employers. And so the Secure Act implemented what are called pooled employer plans as a part of the answer to that problem. Pooled employer plans will take effect for plan years beginning on and after July 1, 2021, and will allow employers of all sizes to join the plan, regardless of whether or not they have any what I would call commonality of interest, meaning, regardless of whether they're in the same interest, same industry, or at the same location, or so forth. Now, a pooled employer plan can be either a qualified retirement plan or an IRA. The pooled employer plan would be administered by a pooled plan provider who would sponsor the pooled employer plan. These pooled plan providers are expected to be, but they don't necessarily have to be, financial institutions. The beauty of the plans essentially would be that to have the cost and burdens on small employers adopting the plan reduced by, first of all, the pooled purchasing power that hopefully would result in lower fees for, let's say, investment management. Also, reduced burdens as a result of the pooled plan provider undertaking some management and administration responsibilities. Now, the Labor Department has not yet issued rules as to exactly what administration responsibilities would these pooled plan providers have to undertake in order to be a pooled plan provider. And that perhaps is going to be, in my mind, the biggest thing that will determine how successful these pooled employer plans will become. To the extent that the pooled plan provider undertakes even more administration than, let's say, these current vendors that offer bundled packages or TPAs, along with these vendors undertake. If the pooled plan providers are going to go beyond that, then this may indeed be a very attractive offer or alternative for small employers that don't have a plan, and frankly, it may even be an attractive alternative for small, medium-sized employers that have a plan, but that have difficulty with the level of administration required under their current arrangement. So to the extent a pooled employer plan could reduce those burdens, it may be attractive for that type of employer as well. However, again, it remains to be seen what Labor Department rules will require, and also remains to be seen, when this is in actual practice, what the pooled plan providers will be doing. I'm just now seeing institutions beginning to, offer these effective next year. The remaining item to reduce the cost and burden would be there will be a single Form 5500 filing for the entire pooled employer plan, and only a single audit, for that plan, assuming there's over 100 participants, which there likely would be. There is something now that's called a multiple employer plan. And some of you may have heard of that, and you may be asking yourselves, well, what's really the difference between the pooled employer plans and these multiple employer plans? Well, previously, employers essentially had to have a commonality of interest, as I mentioned previously, either being in the same industry or the same location to be in a multiple employer plan, because otherwise they would simply be treated as operating separate plans under ERISA. Also, previously, there was what was called a bad apple rule, where any qualification by one employer in the multiple employer plan would result in disqualification of the entire multiple employer plan. And generally, these multiple employer plans would hold that employer liable, of course, for whatever financial damages resulted from that disqualification. And so this was an extreme disincentive for an employer to join a multiple employer plan. Under the pooled employer plans, innocent employers would not be penalized because of a qualification error by another employer participating in the pooled employer plan if two requirements are met. First of all, the assets attributable to the employers of the employer causing the qualification failure must be transferred to either a plan maintained by that employer, an IRA, or another arrangement the IRS determines is appropriate. Secondly, the employer that's causing the qualification failure has to be liable for any resulting liabilities to its employees as a result of that qualification error. Now, one of the big issues confronting employers that want to adopt a retirement plan is fiduciary liability. And I think along with the administrative burdens on running a plan, that's another reason why small employers may not want to get involved in, an ERISA-covered plan. So the pooled employer plan concept tries to address this by having the pooled plan provider acknowledge in writing that it is a named fiduciary of the pooled employer plan and responsible for the administration of the pooled employer plan. Now, participating employers will have fiduciary liability for their selection of the pooled employer plan provider and selection of that pooled employer plan. They would also have responsibility if there's a menu of investment options and some number of those are selected. Of course, that employer would have liability, fiduciary liability for the the investment alternative options that were selected. Of course, to the extent that this is a participant-directed plan where participants direct the investment of, in offered funds of their own balances, and which meets the requirements of a self-directed plan under 404C of ERISA, requiring that you have a certain group of plans that are a group of investment alternatives offered, and that you can make changes at various times, that you can get information, get certain information, then those participants would be responsible for their losses at any rate, and not the employer, who would only be responsible for the selection they made as to the investment alternatives. An employer would also be responsible for providing correct information to the pooled employer provider. Again, it remains to be seen how much administration will be undertaken, but I believe it's hoped that the administration undertaken by the pooled employer plan provider will cover many items, not only testing in the Form 5500s, but handling quadros, resolving disputed claims, employee communications, and perhaps even such things as eligibility, vesting, and so forth. But, again, all of that requires that they get information in the first place. So there would be this requirement to provide proper information. Now, the Labor Department has issued rules regarding registration of the pooled plan providers. And these registration requirements are summarized here on this next slide. The registration is required no earlier than 90 days and no later than 30 days before the pooled employer plan is to begin. There must be information about the pooled plan provider, including the roles that affiliates will have, identification of a compliance officer and agent for service of process, and importantly, existence of any civil, criminal, or administrative actions involving that pooled plan provider. There would be supplemental filings needed as to each pooled employer plan offered by that provider, and also as to any change in the provider's corporate structure, any bankruptcy filing, and so forth. Finally, a pooled plan provider would have to file final Form 5500 upon ceasing operations. So, again, I think it would be important, if you're considering one of these pooled employer plans, to review the information, the registration information the pooled employer plan provider has on file, and further, again, to look at the offerings, because much of this remains to be seen, whether this is going to become the wave of the future, as some expect, because they expect that the administration functions that are going to be undertaken by the pooled plan providers are going to be so much that employers are going to be encouraged, small, medium-sized employers are going to be encouraged to join these, or not. If it turns out that the administration offered is not much different from, what small and medium-sized employers currently get from the vendors that are out there. So that includes my presentation on pooled employer plans, and I'll turn it now over to Lisa.
Thank you, John. So we still have a fair amount to cover. So I'm going to talk now about qualified plan loan offset rollovers. A plan loan offset applies to 401A plans, 403B plans, and 457B plans. So we've been talking about Department of Labor rules for a while. We're now switching to IRS rules. The plan loan offset is an amount by which the participant's account is reduced in order to pay a loan in the event of termination for employment, or sometimes there's a planned termination, like when an acquisition occurs. And generally, a loan is going to be due and payable upon termination of employment unless the plan has otherwise been amended. A plan loan offset is treated as a distribution. That's what makes it eligible for rollover. So it's distinguishable for a deemed distribution that occurs or other things that happen with plan loans. Under existing law, a plan loan rollover only had 60 days to be recontributed. And under the Tax Cuts and Jobs Act, that rule was modified to extend the period of time, but that only applies for what is now called a qualified plan loan offset rollovers. So we're actually talking about two different things with two different time frames, which we'll go into more. The loan offset for a qualified plan loan offset can be rolled over at any time up to the deadline for the participant to file his or her tax return, including extensions. They actually don't have to apply for the extension, but they get that period of time. That's the period in which, for the next tax return, the participant can roll over that qualified plan loan offset. And we'll try to go through some examples. So let's talk about the actual definition of a qualified plan loan offset. And that's an amount that is distributed from a plan because of the termination of employment or the failure to meet repayment terms because the employee has severed from employment. Another requirement to be a qualified plan loan offset is that the loan must have met plan loan requirements immediately prior to the termination or severance from employment. That qualified plan loan offset is only qualified if the offset amount occurs within 12 months after the termination of employment. And under the regulations, the plan loan offset may be rolled over again through the tax filing due date, and it's for the tax year. It's the tax filing that applies to the tax year in which the offset occurs. So if there's an offset in 2020, your tax return gets filed in 2021. There are extensions that may apply to your tax return. You get that period of time to make the recontribution to the plan, or to make a rollover rather. Let's talk about some examples. So there are a number of examples that were in this guidance that the IRS has put out. And I'll just give some high-level examples here. We're going to assume under these facts that a participant had a $10,000 account balance and that they had a $3,000 loan balance at their date of termination, which in our example would be June 15th, 2020. If a plan allows the participant additional time to repay, such as 90 days, that loan offset would have occurred in September. That qualified plan loan offset can then be rolled over until the end of the tax filing deadline with extensions, because there's a rule that allows for you to continue repayment and then to roll over a qualified plan loan offset rollover. If the loan repayment continued in the plan, but the former employee ended up defaulting in July 2021, because remember they terminated employment in June 15, 2020, then they wouldn't have a qualified plan loan offset because they defaulted after that 1 year period. If a loan was required for immediate offset upon termination, then the offset is a qualified plan loan offset, and the employee may roll over that $3,000 in our example until the end of the tax filing period with the extensions. It's possible that an employee also could have elected to receive a cash distribution of their benefit. There would still be an offset, but that loan portion could be rolled over to an IRA or another plan that will accept it. Harriet, I'll turn it over to you.
Thank you, Lisa. And everyone, we're coming up on 1:30, and we still have a little bit more material to cover, and hopefully you'll be able to stay with us. The recording of today's program will be sent to everybody who registered for it. We're going to conclude our program with a discussion of some IRS guidance that came out on the Secure Act. We think of it as a grab bag, meaning that it really just addresses a whole bunch of Secure Act points that are they're not really related to each other than that they're under the Secure Act. And the first, which I'll mention briefly, is the timing for retirement plan amendments to reflect Secure Act provisions. The generally applicable deadline is the end of the 2022 plan year, so over 2 years from now. And for governmental and collectively bargained plans, it's the end of the 2024 plan year, so quite some time from now. However, the plan has to operate in accordance with the Secure Act provision from its effective date, and the amendment would be retroactive to the provision's effective date. And if you would adopt the amendment within that time frame, even if there's some aspect of the amendment that otherwise would cut back a participant's rights in a way that normally cannot be done, that would be allowable. In addition, the IRS notice clarifies that the amendment deadline even applied to optional amendments. So Generally, the rule is that a discretionary or an optional amendment has to be adopted by the end of the plan year in which it's put into effect. The IRS clarifies that if it's an optional amendment implementing a Secure Act provision, you have until the end of the 2022/2024 plan year. I'll turn it back to Lisa to conclude.
Thank you, Harry. So now we're going to talk about, just for a minute, long-term part-time employees. We talked about this in another webinar, I think, back in May. So I'm not going to go through this background here on this slide. What I want to let you know is that there was a notice that was recently issued, and that notice clarifies that the 12-month period that begins January 1, 2021 may be disregarded for purposes of determining whether a participant is eligible to defer a long-term part-time employee, but may not be disregarded for purposes of vesting. So this rule creates a new eligibility criteria, allowing an earlier time for participants who are long-term part-time employees working more than essentially 500 hours per year to be included to make deferrals, but it doesn't require that an employer make matching contributions or non-electives to them. Next was another Secure Act change, and the same notice that I just referenced, there was guidance that was released about qualified birth or adoption distributions that are already available, and this guidance clarifies some things with respect to those distributions, which provide for $5,000 per child or adoptee. There's a 12-month period in which those distributions may be requested after the birth or adoption is finalized. The notice clarifies that the rules apply to 401k plans, 403b plans, and governmental 457b plans. I guess it would be a 401a plan generally too. It confirms that the qualified birth and adoption distributions are optional changes. So a plan does not have to necessarily pick up that change. It's available at the discretion of the plan sponsor. The guidance clarifies also that there are multiple sources that can now be available: elective deferrals, qualified non-electives, qualified matching, or safe harbor contributions are now available, and the plan sponsor gets to determine what sources are available for the qualified birth or adoption distributions. There's in the guidance a requirement of what the tax return information must be. The guidance also clarifies that if a plan didn't provide for such distributions, a participant who meets the criteria could still on their tax return report it as a qualified birth or adoption distribution. The plan administrator, similar to some other guidance, may rely upon a representation from the participant that they are eligible for the distribution, unless for some reason they have information to the contrary. But it is acceptable for the plan sponsor or administrator to request a birth certificate or adoption records. And I think that's all we have time for. If there are additional questions, we will address them by email or contact you. I'm glad that we were able to at least update you on the most recent guidance, and we look forward to working with each of you as these new rules and regulations are being implemented by your plans and by the third-party administrators that you're working with. Thank you for joining us today.